You want to win or lose 99-1, not 51-49, which results in the greatest loss of life, or in this case, money, time, and effort.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
There is another Richard Leibowitz lawsuit. This time, though, we're not talking about Richard Leibowitz being sanctioned. This time we're talking about Richard Leibowitz suing in a copyright case and then losing to a fair use defense. So this will be a fair use case. Yay, we're going back to our roots, fair use. Really, no, I really like the fair use cases, which is exactly why I wanted to do this one. Plaintiff brings this action for copyright infringement. Defendant moves to dismiss for the reasons given below. The motion is granted. Okay, so what do we do first? Whenever we look at one of these things, where are we and who is speaking? This is the United States District Court for the Southern District of New York, and who is speaking? It's Allison Nathan, District Judge. So we know that this is the judge making a decision. This is the judge's opinion and order, and this is from September 24th, so just last week. The following facts are drawn from the allegations in plaintiff's first amended complaint, which are taken as true at this stage of litigation, as well as attached exhibits and documents incorporated by reference. This is normal stuff. The judge is setting the stage for how she's going to refer to the record, or what's going to be in the record. In April of 2017, plaintiff took a photograph of Dan Rockind. The photograph was then licensed to the New York Post, which ran an article entitled "Why I Don't Date Hot Women Anymore" about Rockind and his dating life. So I apologize already for the content. I don't agree with the, making... It's not that you can or can't date hot or not hot people. You have the decision to do that. I disagree with the speaking about it publicly in like a shunning or criticizing way. Like, you just don't criticize people for these things. Just talk about ideas. We don't have to talk about like people, I say as I get done talking about an entire thing about discipline with a person. The post featured the photograph. Defendant posted an article later entitled "Twitter is skewering the New York Post for a piece on why a man won't date hot women." Stick with me, we'll get there. The Mike article, which is the New York Post, this is named for this article that the defendant posted. The Mike article included not the full photograph, but rather a screenshot of the Post article, which includes the headline of the Post article, the author's name and date, and roughly the top half of the photograph. Defendant did not license the photograph, nor did it have plaintiff's permission or consent to publish the photograph. Well, we have the photograph. And so prepare your eyes for the wondrous image you are about to feast upon. There he is. So this is the article. It's literally just a screenshot of the article. So there you go. That's what we're talking about, is this article. This is the offending article, and then this underlying image here is the screenshot that is allegedly infringing on a copyright. On August 21st, plaintiff brought this suit for copyright infringement. That's 2018. After defendant filed a motion to dismiss, plaintiff filed a first amended complaint. So that usually nullifies the motion to dismiss. And then the first amended complaint needs its own motion to dismiss. Sometimes you can just refile the motion to dismiss, but usually have to tailor it then to whatever was changed in the first amended complaint. So December 5th, 2018, defendant filed another motion to dismiss the now amended complaint on the grounds that the photograph was protected by fair use. So the question then is, can you use this kind of screenshot? I'll zoom out a little bit. So like this is on an article. Here's a better thing here. So it's on a Twitter post here, and then here's the screenshot. So is that a fair use or is it not? So we know the motion to dismiss standard. To survive a motion to dismiss for failure to state a claim, which is Federal Rule of Civil Procedure 12b-6. There's a whole bunch of them. There's like 12b-1 through, is there a 7? I think there's 6. I think 6 is the last one. 7. There might be a 7th. 2 of them are sort of repeat. They aren't. They're the improper process and improper service of process. But I think there's 7 of them. I have to look. The complaint must state a claim to relief that is plausible on its face. It asks for more than a sheer possibility that the defendant has acted unlawfully. And if plaintiffs cannot nudge their claims across the line from conceivable to plausible, their complaint must be dismissed. Threadbare recitals of the elements of a cause of action supported by mere conclusory statements do not suffice. On to fair use. The fair use of a copyrighted work for purposes such as criticism, comment, news, reporting, teaching, including multiple copies for classroom use, scholarship, or research is not an infringement of copyright. To determine whether use of a work is fair, courts consider several factors: the purpose and character of the use, for one; the nature of the copyrighted work, for two; 3, the amount and substantiality of the portion used and related to the original work as a whole; and 4, the effect of the use upon the potential market for or value of the copyrighted work. This is known as the market usurpation factor. In considering these factors, the ultimate test of fair use is whether the copyright law's goal of, quote, promoting the progress of science and useful arts would be better served by allowing the use than by preventing it. Fair use is an affirmative defense, and therefore defendant bears the burden of showing that a given use is fair. An affirmative defense may be adjudicated on a motion to dismiss where the facts necessary to establish the defense are evident on the face of the complaint. Accordingly, when the only 2 pieces of evidence needed to decide the question of fair use are the original version and the allegedly infringing version, it is proper to decide the issue on a motion to dismiss. Defendant moves to dismiss on the grounds that its use of the photograph is protected by the fair use doctrine. For the reasons given below, the court concludes that it is possible to adjudicate this motion based solely on the 2 works at issue. The court analyzes each of the fair use factors in turn, while keeping in mind that the purpose of the fair use doctrine is to protect secondary works that add value to the original, that use the original work as raw material transformed in creation of new information, new aesthetics, new insights and understandings to boldly go where no copyright has gone before. I might have made up that last part. The first factor, purpose and character of use, involves 3 subfactors, which involve determining whether the use is transformative for commercial purposes or in bad faith. However, if the new work is substantially transformative, the other factors, including commercialization, are of less significance. The court examines these subfactors in turn and concludes that even drawing all available inferences in a light most favorable to plaintiff, the motion to dismiss standard, this factor strongly favors a finding of fair use. The court concludes that the defendant's use of the photograph is transformative. As to whether a secondary use is transformative, the central purpose of this investigation is to see whether the new work merely supersedes the objects or objectives of the original creation, or instead adds something new with a further purpose or different character, altering the first with new expression, meaning, or message. Copying from an original for the purpose of criticism or commentary on the original. Remember, that's copying from an original for the purpose of criticism or commentary on the original. So remember, I'm always making this argument about how the criticism or commentary has to be directed at something. And it's only if you're directing it at the work, the original work, is it fair use. So this is why I keep saying, you can't use the interview, like somebody else's news interview, without being transformative, substantially transformative. Otherwise, it's not a fair use. Copying from an original for the purpose of criticism or commentary on the original or provision of information about the original tends most clearly to satisfy Campbell v. Acuff-Rose Music's notion of the transformative purpose involved in the analysis of Factor 1. Thus, display of a copyrighted image or video may be transformative where the use serves to illustrate criticism, commentary, or a news story about that work. On the other hand, if a photograph is merely used as an illustrative aid that depicts the subjects described in an article, that does not constitute transformative use. This is important. Pay attention. On the other hand, if a photograph merely is used as an illustrative aid that depicts the subjects described in an article, that does not constitute transformative use. Applying that standard, even drawing all available inferences in plaintiff's favor, Mike's use of the photograph was transformative in 3 ways. First, it is clear from the face of the Mike article that it was using the screenshot to identify the subject of controversy, the Post article, and to illustrate why the article has been controversial. Using a portion of an original work to identify and inform viewers about the subject of a controversy can constitute transformative use. For example, a news report about a video that has gone viral on the internet might fairly display a screenshot or clip from the video to illustrate what all the fuss is about. Again, the difference there is that it's about the video itself, not about the contents that are shot by a news organization or something. Similarly, depicting a controversial photograph could be fair use as an accompaniment to commentary about the controversy or criticism of the photograph. This is the case here. The title of the Mike article, "Twitter is skewering the New York Post for a piece on why a man won't date hot women," immediately informs that the subject is the backlash to the Post article. In a similar case involving a Post article, the fact that the original photograph was not reproduced as a standalone image, but as part of a composite image that shows the manner in which the Post article's headline, author, byline, and the photograph were arranged on the Post website, indicates this is being used to identify the subject as the Post article itself. So not just a mere reproduction of the article. The Mike article itself consists in large part of embedded tweets criticizing the Post article, the way the Post article presents Rockend and Rockend himself. One of the embedded tweets commenting on the photograph writes, quote, "Sorry ladies, but you just lost your chance with Mr. February from my passively hot substitute teacher's calendar." End quote. This not only pokes fun at Rockend as he is depicted in the photograph, but also the idea that his opinions on hot women would be reported seriously in the way the Post has done. Another tweet commenting on a different photo from the Post article states that the photo's caption is so savagely written, this has to be a piece of satire. In this context, the photograph is used to illustrate what all the fuss is about, namely the Post article and its depiction of Rockend. This is a different use of the photograph than the Post's, which was news reporting on Rockend. To the extent that the photograph was used as part of the composite screenshot to identify the Post article itself, it indisputably constitutes a different use than its original purpose. Second, it is clear from the face of the Mike article that it does more than just comment on the controversy. It uses the screenshot as part of its own criticism of the Post article. In a recent case in which a blog used a composite screenshot of a news article, as here, the composite included the headline of the article, the author byline, and the photograph at issue. To criticize the original article, Judge Marrero held as a matter of law that this use was transformative, as the photograph is no longer just a depiction of the original subject, but a sly barb at the original article's sloppy journalism. Similarly, the Mike article mocks the Post's presentation of the subject, using the screenshot to both identify the target of its criticism and as a basis for criticism. The screenshot juxtaposes the photograph of an individual whose appearance the article mocks with a headline sincerely proclaiming that this man won't date hot women, as an attempt to emphasize the humorous incongruity of the Post's decision to run the photograph in the way it did. The Mike article goes on to criticize the Post article in a number of ways, mocking the way the Post refers to Rockend's fiancée as merely beautiful rather than hot, and launching jabs at the Post for transmitting Rockend's self-presentation at face value. Quote, "The 40-year-old Upper West Side resident humbly told the Post there was a time when he could have had anyone he wanted, which meant he always went after the hottest girl you could find," end quote. Accordingly, quote, the photograph is no longer just a depiction of the subject, end quote, but a vehicle for criticizing the post article and identifying it as the target of this criticism. This brand of media criticism is not the same purpose as the photograph was originally intended to be used. In this manner, defendant's use added something new with a further purpose or different character, altering the first work with new expression, meaning, or message. Third, on its face, the Mike article uses the photograph to place Rockin in a harshly negative light, while the original use of the photograph placed him in a positive or at least neutral light. In the context of news reporting and analogous activities and the reproduction of a work without alteration, courts often find such uses transformative by emphasizing the altered purpose or context of the work as evidenced by surrounding criticism or commentary. Accordingly, several courts have held as a matter of law that it is transformative to take a photograph initially used to simply identify someone or show them in a positive light and use it in a critical manner. Even while this use comes closest to the post's original use of the photograph depicting Rockind, using the photograph to criticize Rockind is a reframing of the meaning or message of the original work. In the original, the posed photograph dominates the page, accompanied by text describing Rockind as having had no problem snagging the city's most beautiful women and praising his muscular build and a full head of hair. A reasonable viewer would interpret the photograph in this context as placing Rockind in a flattering or at very least neutral light. In sharp contrast, the screenshot in the Mike article shrinks the photograph considerably and places it alongside text in which this insufferable private equity executive is mocked for everything from his appearance to his personality. The use alters the original message of the photograph, dramatically altering the light in which it is framed and the message it conveys. None of the plaintiff's arguments to the contrary are availing. It is true that the unauthorized use of a licensed work is not protected solely because the secondary work has a purpose or message that was different from that of the appropriated material. Accordingly, simply reducing a comedy routine unaltered in a play that is a dark critique of society will not constitute fair use if the comedy routine itself does not convey that dark critique. However, here, the photograph is itself being used to illustrate the controversy around the Post article as satirical commentary on the Post's reporting and to portray Rothkind in a different light. In light of the above, even drawing on all inferences in plaintiff's favor, it is implausible that Mike's use of the photograph was not transformative in the three ways described above. Given the importance of this subfactor, it counts heavily in favor of finding that the use was fair. The commercial nature, the second fair use factor, plaintiff alleges that defendant is a for-profit media organization that derives substantial revenue from advertising. Accordingly, this subfactor counts against finding fair use. However, when the use of the work was transformative, this factor is of less significance. Because fair use is an affirmative defense, it is defendant's burden to show that it did not act in bad faith. At this stage, absence of bad faith must therefore be evident on the face of the complaint. This is not so here, as viewing plaintiff's allegations in a light most favorable to plaintiff, defendant cut off part of the photograph, removing the label crediting the work to plaintiff. The intentional removal of a copyright mark can suggest bad faith in defendant's use of plaintiff's work and militate against a finding of fair use. However, the Second Circuit has cautioned that bad faith is not itself conclusive of the fair use question or even of the first factor. This subfactor thus counts somewhat in plaintiff's favor. The nature of the work. Even drawing all available inferences in plaintiff's favor, the second factor, the nature of the work, does not point strongly in either direction. The Second Circuit has identified two subfactors to consider: whether the work is expressive or creative, such as a work of fiction, or more factual, with a greater leeway being allowed to a claim of fair use where the work is factual or informational. And two, where the work is published or unpublished, with the scope for fair use involving unpublished works being considerably narrower. As to the first subfactor, The court agrees with plaintiff that while the photograph is a relatively straightforward depiction of Rockend as a posed portrait, it evinces at least a modicum of artfulness sufficient to designate it as creative rather than factual as a work for the purposes of a fair use analysis. However, while this classification cuts against a finding of fair use, this factor has rarely played a significant role in the determination of a fair use dispute. For the second subfactor, it is evident from the face of the first amended complaint that the photograph was previously published when defendant used it. Accordingly, the second subfactor counts in defendant's favor. Given the above, even drawing all available inferences in his favor, the second factor counts only slightly in plaintiff's favor, if at all. The third factor points towards a finding of fair use, even when drawing all available inferences. In this factor, the court will consider the amount and substantiality of the portion used in relation to the copyrighted work as a whole. The question is whether the quantity and value of the materials used are reasonable in relation to the purpose of the copying. The law does not require that the secondary artist may take no more than is necessary, and the secondary use must be permitted to conjure up at least enough of the original to fulfill its transformative purpose. Yeah, I think that was a misstatement. The law does require that the secondary artist may take no more than is necessary to make the transformative purpose or make the fair use, and the secondary use must be permitted to conjure up at least enough of the original to fulfill that transformative purpose. If copying the original any less would make the picture useless to the story, the substantiality of the copying is of little consequence. Here, defendant used a significantly cropped version of the photograph as part of a screenshot including the post article's headline. Even drawing all available inferences in plaintiff's favor, it is implausible that this was not a reasonable use of the photograph to achieve the purpose of both identifying the object of controversy and satirizing the post article and Rockend. Plaintiff offers a number of alternatives that he claims would have been less infringing. Even drawing all those inferences in his favor, none of those are convincing. Plaintiff contends that defendant could have published its news story with only the Twitter embeds, showing multiple instances of the photograph and perfectly illustrating both the Twitter reaction and Mr. Rockend himself. However, the secondary work is not required to use only the absolute minimum of the absolute work necessary. The use of the screenshot in the Mike article's headline identified the post article as the subject, and it is not plausible that Mike could have achieved the same effect by burying the lead in embedded tweets. The other alternatives are similarly implausible. Plaintiff offers that defendant could have shared or commented on the original story, presumably without writing their own, but it would not be reasonable to infer that this would be a replacement for an entire article and accompanying embedded tweets. Requiring defendant to publish its news story without any photo whatsoever would not be enough to achieve the transformative effect for the reasons given above. If defendant commissioned its own photographer to take an original photo of Rockend, this would fail to produce an image that identifies the post article. Similarly, since defendant uses the photograph as part of a screenshot to identify the post article itself, even drawing all available inferences, it is impossible that licensing the standalone photograph would serve the same purpose. So they couldn't just have licensed the photograph. The screenshot showed the photograph as used in the context of the post article, and accordingly, a licensed standalone image would not have accomplished the same transformative purpose. And the market usurpation factor. When a secondary use competes in the rights holder's market as an effective substitute for the original, it impedes the purpose of copyright to incentivize new creative works by enabling their creators to profit from them. The Second Circuit recently noted that the Supreme Court described this factor as undoubtedly the single most important element of fair use. So listen up, as its market usurpation factor is the single most important element of fair use. This factor focuses on whether the copy brings to the marketplace a competing substitute for the original or a derivative, so as to deprive the rights holder of significant revenues because of the likelihood that potential customers, may opt to acquire the copy in preference to the original. So if I take your work, add a little bit to it, maybe dress it up a little bit, and then sell it as my own, that's market usurpation. But if I take your work, dress it up a little bit in the form of tremendous criticism and commentary, and I only use the amount necessary to make my point, like the third fair use factor, then that's transformative and not usurping the market, because people can't just go buy my work in order to act as an effective substitute for yours. Here, even assuming that there were a market in licensing the photograph and drawing all available inferences in plaintiff's favor, it is implausible that such a market would be supplanted by defendant's use. As noted above, the photograph does not appear on its own in the Mike article, but as part of a composite screenshot, including the post article's headline, the author's byline, the date and time. In light of the cropped and composite manner in which the Mike article presented the photograph, it is implausible that potential purchasers would opt to use the screenshot rather than license the original photograph. As in Clark, a screenshot of this kind does not function as an illustration of Rockind because it also contains the post article's headline and author byline. Thus, the screenshot does not compete against the photograph in the enterprise of depicting Rockind. There is little risk that someone looking to license or purchase an image of Rockind would select the screenshot instead of the photograph, thereby potentially diverting revenue to Mike that would have otherwise gone to Yang. Indeed, the argument here is even stronger than in the Clark case. Here, the photograph was cropped significantly in size, while in Clark, the entire original was used. Accordingly, even drawing all available inferences in plaintiff's favor, it is not plausible that the screenshot would usurp the market, if any, for licensing the photograph. In light of the above factors, even drawing all reasonable inferences in plaintiff's favor, it is evident on the face of the First Amendment complaint that defendant's use was fair as a matter of law. Defendant's use was transformative. Its use was reasonable in light of that end. The work was already published. There is no plausible risk to any market for licensing of the original work. This is sufficient to make out an affirmative defense of fair use at the motion to dismiss stage. Because defendant prevails on the issue of fair use, it is unnecessary to reach the question of alleged willfulness. For the reasons given above, the court grants defendant's motion to dismiss. Plaintiff has already amended its complaint once in response to defendant's initial motion, which pressed the same arguments as those raised here. Moreover, plaintiff has not requested an opportunity to amend, nor stated what amendments, if any, he would seek to make. For those reasons, this dismissal is with prejudice, meaning it cannot be filed again. This resolves docket item 19. The clerk of court is directed to enter judgment and close the case. Allison J. Nathan, United States District Judge, September 23rd, 2019. So that was a Leibowitz case that lost on fair use grounds, and the defendants instead won a motion to dismiss and should be making some sort of agreement or asking the court to order fees and costs to be paid under 17 U.S.C. 505. So hopefully we'll see Leibowitz have to pay for that case instead of the other way around.
What is the difference between a finding of fair use at the motion to dismiss stage versus at the trial stage? Like, how is this different or better for the defendant?
It happens earlier for the defendant at the motion to dismiss stage. So here, the plaintiff would have filed a complaint. Then there was a motion to dismiss, no answer to the complaint, no discovery of evidence, no litigation yet. The motion to dismiss is the litigation. It's called motions practice. So the motion to dismiss gets filed. The first amended complaint negates or moots the motion to dismiss, the first motion to dismiss, or the motion to dismiss the original complaint. And then the first amended complaint is now the operative complaint. If that satisfied the party filing the motion to dismiss, then they could answer the complaint instead. What they did here, though, was file a second motion to dismiss, this one called the motion to dismiss the first amended complaint. If you're counting, it's the second dismissal, but it's the first amended complaint. We're now calling it the amended complaint, so it's the first one. And so that is a second motion to dismiss. It's the first motion to dismiss the first amended complaint, if that makes any sense. And so the judge needs to do this like little extra analysis we saw at the beginning, like really, can I resolve fair use questions here? Do we have enough information to resolve fair use questions here? Or do we have to go to a fact finder? If there needs to be fact finding, that can be taken care of in discovery. Or if there are still controversy after discovery, Fact-finding can be done by the judge if the parties agree, or has to be sent to a jury. And then the jury has to decide what the facts are and find the facts to be one way or another. All this is molded by the court process. So you avoid all of that. You avoid discovery, you avoid pretrial motions, you avoid jury instructions, you avoid jury selection, you avoid a jury trial. And then you get all of this now and done now. So Leibowitz will owe substantially less money than he would if he lost after a jury trial. So this is actually good for everybody. This is even good for a losing party to lose early rather than late. You want to win or lose 99-1, not 51-49, which results in the greatest loss of life, or in this case, money, time, and effort. So what do you think of that? Leibowitz got smacked down again. Dun, dun, dun. All right, so that is our show, everyone. Thank you for joining me. I am Leonard French, your favorite copyright attorney. Thank you for all of our supporters in the month of October. Joshua Davis has sponsored our channel for the month of October again. Also, thank you to our $50 plus supporters, Joe Tyson, Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Blackleaf, and Benjamin Hitov, or Hitov. Apologize for mispronouncing your name, Benjamin, let me know. And thank you to the $5 plus supporters that are scrolling on the LED panel behind me and will be in front of my face here on the crawl. Yes, we are still doing a stream on Wednesdays, although it doesn't always happen on Wednesdays. This week it happened on Thursday because I wasn't feeling so well on Wednesday. The Wednesday stream is kind of flexible, but welcome Brandon, who is now editing for us on a more full-time dedicated basis. So hopefully we'll be able to put out not just more videos, but higher quality videos. I have a green screen to play with, so this is fun trying to bring these things to you here with then like Leonard's cutout thing. Maybe it looks a little more professional. So things are slowly improving. So thank you for all of your support on patreon.com/ljfrench and sponsors.com/law. Without your support, this wouldn't be possible. I really appreciate it. So that's what we'll leave you with today. I will see you in the videos that drop. Love you all. Have a great weekend, great week, and I'll see you next time.